Today we are looking at the organization of political power in the United States of America. The political system in the United States is organized around a federal system of government that encompasses 50 different states. It is important to note from the outset that the 50 states are separate legal entities and not just administrative units created by the federal government to facilitate governing the country. Indeed, it was the state governments that created the federal government, and not the federal government that created the states. Both federal and state governments are organized around Montesquieu's theory of the separation of powers, each having an executive, legislative, and judicial branch of government. So what is the relationship between the federal and state powers? As we have seen, the American legal system is built around two distinct legal systems. The federal system established by the US Federal Constitution, which came into effect in 1789, and the legal system of the 50 individual states, 13 of which existed prior to the creation of the federal state. The basic principle governing the relationship between federal and state power is as follows. Federal law is supreme over state law, but the scope of federal power is strictly limited to those areas expressly set out or enumerated in the US Constitution. Consequently, outside of these areas, each state adopts the laws it considers appropriate, and as a result, each of the 50 US states has its own specific character. This is particularly true as state law governs most of the areas that impact people's lives on a daily basis. For example, areas such as family law, contract law, company law, and education all come within the remit of the individual states. Now let's take a closer look at the exercise of federal power in the US. The federal government of the United States was established pursuant to the provisions of the United States Constitution. Federal power is divided into three branches: the legislative, executive, and judicial branches of government. Thus, there are three individual powers. However, the system of the separation of powers is not applied rigidly insofar as each power can, to varying degrees, control the power of the other two branches. This is referred to as the system of checks and balances. Under this system, each branch of power exercises partial control over the exercise of power by the other federal branches. Thus, the undue concentration of power in any one branch of government is prevented. Now let's take a closer look at the federal legislative power. Federal legislative power is conferred on the Houses of Congress, which are comprised of the House of Representatives and the Senate. The House of Representatives has over 400 elected members, each of whom represents a congressional district in the United States and serves for a 2-year period or term. Seats in the House of Representatives are apportioned by reference to population numbers. Thus, more heavily populated areas, such as New York State, will have more House representatives than less populous areas, such as the state of Montana. In contrast, in the Senate, each state is represented by 2 senators, no matter the size of its population. Consequently, the tiny state of Rhode Island has 2 senators, as does California, which has a much larger population and is a global economic powerhouse in its own right. As there are 50 states, consequently, there are 100 senators, each of whom serves a 6-year term. However, 1/3 of the Senate stands for election every 2 years, and thus, every 2 years, significant senatorial and House of Representative elections take place in the United States. As we have seen, Under the system of checks and balances, each of the congressional chambers enjoy both exclusive powers and complementary powers. For example, the approval of the Senate is required for many of the important appointments made by the executive power, whilst the House of Representatives has the exclusive power to introduce or propose fiscal measures or bills. However, the support of the Senate is required if such revenue bills are to pass into law. The actual powers of Congress are limited to those areas specifically enumerated in Article 1, Section 8 of the US Constitution, and include, inter alia, the power to levy and collect taxes, the power to provide for a common defence, to establish post offices and roads, to issue patents, to create federal courts inferior to the Supreme Court, to declare war, raise armies, provide and maintain a navy, etc. Now let's look at the executive power, the President. Executive power in the US federal government is vested in the President of the United States. The President is the head of state of government and the military commander-in-chief and chief diplomat. The main power of the President is to take care that the laws of the United States be faithfully executed and to also preserve, protect, and defend the Constitution. Moreover, as we have seen, the President has the power to either approve legislation passed by Congress or alternatively the power to veto such legislation. The President may also, with the consent of 2/3 of the Senate, make treaties with foreign nations. The President has the power to pardon or release criminals convicted of offences against the federal government and also the power to enact executive orders. Executive orders are a secondary form of legislative instrument, like a decree, and the President's power to adopt such orders has been criticised by some as a usurpation of Congress's legislative role. Indeed, nowhere does the Constitution specifically give the President the right to adopt such orders. Rather, it is inferred from the duty to ensure that the laws of the US are faithfully executed. Finally, with the consent of the Senate, the President has the power to appoint Supreme Court justices and federal judges. Now let's take a look at judicial power and the Supreme Court. The US Supreme Court is the highest court in the federal court system and deals with cases concerning the federal government and disputes between states. It has both original and appellate jurisdiction, and its most important power allows it to interpret the provisions of the US Constitution. Pursuant to this latter power of interpretation, the Supreme Court can declare legislation adopted by Congress or an executive action of the President to be unconstitutional and consequently null and void. This is referred to as the power of judicial review, i.e., the power to review judicially the legality of the acts of the other branches of federal government. The Supreme Court can also declare unconstitutional acts of the 50 state executive, legislative, or judicial powers, as federal law is supreme. Members of the federal judiciary may be impeached by Congress, as indeed may the President. Now let's take a look at the place of the 50 different states making up the United States. As in the federal system, power in each individual US state is organized pursuant to Montesquieu's system of the separation of powers. Each state has a legislative power, an executive power, and a state judiciary. Moreover, each state has its own constitution. State governors, representing the executive power, normally hold office for a 4-year term, although in a few states the term is only for 2 years. As the states have regulatory powers over all the areas not specifically granted to the federal government, They have wide powers over education, company law, and fiscal policy, to mention just a few areas. It is the function of the state courts to apply state law governing these areas. Although federal and state powers in the US are significant, there is also a vibrant system of local government in the United States. Indeed, the system of local government is widespread, governing geographical areas referred to as counties, municipalities, townships, and school districts. Each of these areas has a locally elected ruling body, referred to collectively as local government. Local government bodies are responsible for providing services such as police protection, the development of sanitary codes, health regulations, education, public transportation, and housing. Cities are generally run by mayors, who then appoint officials to head each of the city departments, normally acting with the approval of the city council, a type of city legislative power. The city council is usually responsible for city ordinances, the setting of rates, i.e. taxes on property, managing the city budget, and apportioning money among the various city departments. Finally, political pressure groups play a very important role in the political organization of the United States. Special interest groups play a very important role in the legislative adoption process in the United States. These groups support the political and economic agendas of their members and lobby politicians to this end. One important type of private interest group that has grown in influence is the Political Action Committee, PACs. Numerous PACs have been established and are often organized around a single issue or cause. For example, a group might be pro or indeed anti-abortion and contribute money to political candidates that support their policy position. Although PACs may be limited in the amounts they can contribute directly to candidates, there are no restrictions on the amounts PACs can spend independently to promote their candidate. Thus, they often pay for advertisements in favor of the candidates they support. There is a feeling in some quarters that these groups have to some extent hijacked the democratic process in the United States, and that it is the interests of these groups, rather than the interests of the general populace, that Congress promotes. The result of the interaction of federal, state, and local powers is a dynamic form of democracy, reinforced by the fact that there are significant elections taking place annually in the United States. This has been criticized on the grounds that it results in the election of political leaders overly influenced by short-term political concerns. And although this is possibly true, it is also a significant ingredient in a system where change is welcome and where people truly feel that yes, they can. We hope you enjoyed this introduction to the organization of political power in the United States.